Hi, I'm Chris Chimicles, president of Angeion Group, and welcome to our Leading Litigators series. Our series brings together some of the best and brightest class action practitioners from both the plaintiffs and defense bars, and most importantly, the attorneys that made case law. Enjoy our series.
Hi, I'm Steve Weisbrot. Thank you for joining us for Angeion's Leading Litigator video series. We are here today with Shon Morgan from Quinn Emanuel. Shon heads the class action practice group, and it's our distinct pleasure to have him join us. Thanks for joining us, Shon.
Thanks, Steve. Great to be here.
Shon, it's no secret we're seeing more and more judicial scrutiny of settlements, class action settlements. And we're seeing stuff like the Pella decision in the Seventh Circuit. We're seeing a general disfavor towards cypre distributions. How is this affecting defendants and the defense bar who want to come forward and want to settle a case but are sort of handcuffed by the recent scrutiny that's come down from the Supreme Court and the circuits?
Well, the scrutiny is good. It's helpful to the process and to the end product and the settlements. And I think judges often, as a fresh set of eyes, offer valuable refinements to the settlements. I think the danger is when judges through no fault of their own, make statements in the context of a particular case that then get interpreted among the litigants as categorical rejections of certain structural elements within settlements, cypre being a good example. I think the instances where courts have had concerns about cypre we're very particularized to those cases, and we're not an attempt by the judges to say that we will never accept these inappropriate instances. And I think that one of the things that's important for litigants to do is realize that all of these elements that are often demonized, such as cypre distributions, reversions, claims made settlements, still all remain viable tools in the settlement toolbox, and can and should be used in appropriate cases, and it's the responsibility of the litigants to show the courts why they make sense in a given context.
Sure. One of the hot button topics across our industry right now is ascertainability, and the tension is obviously between a defendant's alleged due process rights and the fact that lots of people do not keep receipts for small value items. What are your thoughts on this? Are we going to hear from the Supreme Court? Are we going to hear from the Rules Committee? Is it just going to keep playing out in the lower circuits? What do you think is going to happen?
Well, as I was just saying, I think a lot of these decisions are very contextual, and it's easy when Carrera comes down or the first couple of follow-on decisions to say, oh, well, every other case is going to fall in line, and we're never going to have a class certified again for low-cost consumer products. And then you have, for instance, Judge Koh in the Northern District of California, who came out with two decisions on product lines that in some ways would appear indistinguishable, but she was able to draw lines and say that I believe in one case it's ascertainable and in the other instance it's not. So I don't think that we're going to have this sort of doomsday end to class actions over low-cost products. Now, with respect to ascertainability, my concern, although as a defendant I think these cases were largely decided the right way, I'm not entirely comfortable with the analytical framework. Ascertainability, as you know, is an implied requirement and traditionally has applied to the class definition, whether you could apply objective criteria to deciding who's in the class.
Right.
And I'm not sure that these decisions all fall in line with the purposes of the ascertainability requirement. It seems to me that superiority and predominance, which were separate prongs that are already existing, are a much better framework under which to analyze the very real problem of being able to identify the consumers who bought these low-cost goods. I think it would be easy for a court using their broad discretion at class certification to say, in a given instance, here it's not a superior use of the court's resources to certify a class where we may have insurmountable difficulties identifying class members. And one follow-on point that it goes back to your previous question about settlement. Ascertainability is another one of those issues that I think has caused some difficulties with settlements, because if a court is saying that these sorts of classes aren't ascertainable, well, then technically they shouldn't be certifiable even for settlement purposes.
Right.
Yet the cases are being filed, and both defendants and plaintiffs would like to settle many of them. And so having alternatives available to direct payment, such as a cypre distribution, are a very appropriate way to handle cases like this where ascertainability has been flagged as an issue.
Shon, as you know, one of the things that I'm particularly passionate about as it comes to my career is using new and emerging media, digital media, social media, to help attorneys reach potential class members in the notice and settlement stage of these cases. What's your take on that as just a general paradigm? Do you advise clients to use it? Why or why not?
It's inevitable that we're going to move towards using those means of notice. Obviously, compared to direct mail and other types of publication print, it's generally much more cost effective. But we've historically seen a lag between the availability of new technology and its implementation in the settlement or notice process. And we saw that 12 to 15 years ago with email. For a long time after email became ubiquitous, courts still weren't using that with any consistency as a form of notice. And now that's become the primary form of notice where it's available. So I think we'll see the same thing with the new technologies. I think the differences in what courts are struggling with right now, as opposed to emails or direct mail or even publication notice, judges were very confident about the context in which notice was being provided under those methods. The recipient wasn't going to be given any collateral messaging about the settlement, pro or con, and the surrounding context of the New York Times, for instance, was essentially content neutral, or at least sufficiently so that the courts weren't concerned. Whereas when you're looking at various internet sites, there could be other forms of content on there that is completely out of control of the judge and with no ability to monitor it that is a concern for them. I think if we jump ahead, though, 5 or 10 years, as this technology becomes to rapidly evolve and we see, for instance, the Yahoo homepages that are tailored to an individual's particular viewing habits, buying patterns, interests, that ability to target people will only increase exponentially as we go forward.
Sure.
And soon we'll get to a place where courts won't have to sort of sweat the details of the notice plan. I think they'll be able to, with a high degree of confidence, just say, put the press release out, and technology will do the job of finding the people who are the most appropriate recipients for this. And a lot of these questions will go away. I mean, that won't change the role of administrators in administering settlements, in forming the content of notices, but the notice process itself, I think, will become much more streamlined as this technology evolves.
Shon, we really value your unique perspective. We appreciate you being here. We think you brought a lot to the table, and our viewers are really going to enjoy hearing this.
Great. It's a very interesting series. Thank you for letting me be a part of it.
Thanks.